I can't believe I'm standing in front of you today, in this place, in Boston. How is it the year I become president of the American Immigration Lawyers Association, its annual conference is in New England? How lucky can I get? How is it the year I become president of AILA, its annual conference is in an upscale mall? How lucky can the stores get? I heard there were rumors about whether or not I would actually make it to this podium on time. Really? Everyone knows the stores don't open till 10. Welcome to New England, my home, the home of my chapter, the New England chapter. They have always made me feel like a part of their family, despite the fact, and in the words of a true New Englander, you can't get that from here. At least not in time for an after-work chapter meeting. Nevertheless, I was always welcomed with open arms. Thank you, New England, for your friendship, your support, and your hospitality. I love you guys. You rock. It truly is kismet that I get to start my presidency in New England. It's where I found immigration. And I think if I had not found immigration, I would not be practicing law. I started my career in New York as a commercial litigator. However, I started my true career, or found my calling, as I truly think the case may be, after moving to Vermont. I actually found it through dance in Vermont. Oddly, African dance in Vermont. Go figure. This comes as no surprise, I suppose. I love to dance. I will tell you that early on in my career, as I was growing up, that I was never going to be able to make a career of it. In fact, I sprained my ankle so badly in ballet as a young child, my father told me to take up prize fighting. I took his advice. I became a litigator. But I never stopped dancing. In 1997, I began attending African dance classes in Burlington. We were blessed with having several members of the National Ballet of Guinea, Mali, Senegal, the Ivory Coast. Yes, guess what? They were all P3s. That's back when you could get them here. After class, they'd ask me questions about their immigration status. They sought me out because not only did I practice law, at least somewhat, I also spoke French. I was fortunate enough to have attended the L'École Française in New York from 8th grade, or from kindergarten to 8th grade. But I knew nothing about immigration, so I referred them to a truly terrific attorney in Burlington. I distinctly remember my first task after turning to immigration law. I sat down, I'd been practicing for a long time, and she gave me my first assignment. She asked me to determine whether a client who was coming into the office the next day, or in 2 days, had been admitted. Admitted? Of course, they were here. Of course they'd been admitted. Well, 2 days, 16 hours later, I realized I'd entered a world where nothing was as it seemed. It was, and still is, however, my wonderland. Thank you, Debbie Volk, for being my reaction specialist and for giving me the key that started my adventure. 5 years ago, when I started on the trek to this podium, an ex-president and one of the smartest women and best lawyers I know told me that it was time to start thinking about my presidency and what I hoped to accomplish. That if I waited until this year when I became president, it would be too late. I took that to heart. I knew if she thought it would take 5 years to get something accomplished, then this was going to be harder than I thought. She was so right. Hell, it's been 5 years, and I can't tell you in what color to sign your forms. To tab or not to tab still remains the question. Each year, when I submitted my request to be nominated for the executive committee, I set out my goals. I reviewed those submissions recently. It was a great exercise, and it provided an interesting retrospective of the past 5 years. It allowed me to see what had been resolved and accomplished, what issues recur over and over again, and which issues still remain, and with those, which of my goals have not yet been reached. The majority of my priorities and goals varied from year to year, as they were necessarily dependent on the year's issues du jour. One issue, however, remained constant. Ironically, it was the lack of consistency and predictability in adjudications, determinations, rulings, and admissions, and the need to fix those through, among other things, interagency engagement. Our world requires that we typically deal not with just one agency, but two, and generally three. This is a constant in all areas of our practice, whether it be family, business, or removal. Think of H-1B visas or petitioners denied, or applicants denied after admission, denied after petition approval, or approved fiancés who never get here. Actually, in our office, we call those love's labors lost. Or waiver applicants with provisional grants denied on other grounds not previously believed to make one inadmissible. The interagency disconnect is not limited to petition, visa, and subsequent admission situation. It's also at the heart of so many of our procedural problems. How or could or shall someone in proceedings pay before the IJ pay the fee for a waiver when the case is remanded back to USCIS? Which agency should endorse a blanket L when an applicant's 5-year visa remains constant, still valid? And how or should a student in OPT travel during their cap gap period? It makes sense that my primary long-term goals relate to AILA's liaison work. One of the many benefits of living in Vermont, other than being able to put maple syrup on everything, is that I learned to practice immigration law in an area where I truly had access to government. I went to the border. I went to the Vermont Service Center. I used to tie my dog up right outside. I had lunch and potluck lunches with the VAWA unit. If I needed something from our local USCI office, I called them and asked. I met and had lunch with our SWA to discuss the local labor market. I distinctly remember when early on in my career, I had a client who was unable to get their Social Security card because the information from INS, either from the border or from the local office, was not visible or available to Social Security Administration. We went back and forth, and finally someone suggested that we all sit down and talk about it. I called them and asked to do so. We did. Within 1 week, my client had their card, and I have not seen that problem in my local office since. Until I became active in AILA, it never ever occurred to me that this was not the norm. Having learned to practice in an area where openness and accessibility continue to be the standard has guided my vision. Those of you who have sat with me in liaison meetings know that I typically have 2 recurrent themes. Well, actually 3. Doug, can I borrow your jacket? Because it's so damn cold in here. But the first is that my local USCIS, my CBP office, and my ICE offices are the exemplar, truly. I've never ever felt that I couldn't talk to them and they wouldn't listen. We don't always agree, but they care, and they're fair. And it's for this reason that I press on in liaison, because I know and I believe that we can make it work. The second is an ask I make at each and every meeting. That is, whether the agency we are meeting with is willing to meet with us together with another agency or agencies. I believe that many of our adjudication and process problems stem from the fact that two or more agencies have conflicting interpretations of the law or regulations, and they don't know the effect that their actions have when that applicant has to deal with another agency on that same issue. Take, for example, CBP's recent move to the automated I-94. The I-94 regulations require that an employee present an I-94 to start work. The regulations now state that a passport stamp is an I-94. However, if an intended employee cannot find their I-94, they can't begin work. But the H-1B regulations require them to report for work. They also require to begin paying that employee, or that they require them to pay the employee, but they can't pay them without the I-94. Thus, the seemingly switch just from paper to online printing of an I-94 has created a procedural problem that we can't fix at the moment. I believe, I truly do, that we can solve this problem if we're just permitted to sit down with CBP, USCIS, and ICE and develop a solution. I want to see that happen. I actually think this goal is attainable. Just this year, in this past April, we were invited to attend a meeting arranged by EOIR that included ICE and USCIS. It was the first time in my tenure that this occurred. A good and productive time was had by all. And to paraphrase from what I think is the greatest immigration film of all time, I am hopeful that this was the start of a beautiful friendship. Interagency engagement is not the only answer to attaining more consistency and predictability in what we do. And if I were putting myself forward for nomination to the executive committee this year, I would have focused on the need to locate, isolate, and change the negative policy that seems to be driving so many of our adjudications, decisions, and admissions. In our area of practice, and I think more than in any other, discretion abounds. When I first started practicing, discretion was more often than not exercised generously. It never would have occurred to me to tell a large multinational company with an individual who'd been employed by it in a highly technical, high-level position overseas for 50 years that it was possible and probable that a determination would be made that he did not have specialized knowledge about that company. Never would I have thought that I would have to explain to a client who was here, who had filed for an adjustment application, that they were actually authorized to work and could do so, but they nevertheless could end up in deportation proceedings because they actually still were not allowed to be here. And I gotta tell you, I still don't understand that one. It would not have occurred to me to advise a professional dance and drum teacher who clearly met all of the requirements for P3 status and visa issuance, that he could not and should not return home to obtain new and current dance moves and visit with his family, because likely he wouldn't come back. Earlier I told you I found immigration through African dance. But not only did African dance lead me to immigration, it taught me immigration. In representing the dance community, I encountered early on in my career almost every immigration situation there is. I learned to prepare P3s, O1s, EB1s. I was able to, for a lucky few, take advantage of the short period of 245I reappearing. Remember that? I also learned about NTA's adjustment of status before the immigration court, how to overcome an I-751 denial before the immigration court. The good news is I was able to help almost every one of those people who found themselves in trouble. That is, until at least fairly recently. Almost 3 years ago, one of my star drummers returned home to Guinea to visit his family and bring back new and current dance rhythms. He had an approved P3. It was his second. He played and taught only African rhythms. He taught classes in middle schools, high schools, universities. He never violated his status. He'd never been in trouble with the law. He brought cultural diversity to an area where it was few and far between. He was the prime example of what the P3 was created for. But despite having an approved P3 petition, his visa was denied for immigrant intent. None of us have seen him since, and I suspect we won't again unless we travel to Guinea. Thankfully, with every yin, there is a yang. I also have some good news to report. Last month, our principal dancer and drummer became a US citizen. In a few months, my dance teacher will hopefully become a US citizen. When I drove Ismail to his naturalization interview, I heard him recite perfectly every answer to every question on that civic CD. What is the Constitution? It is the law of our land. Hell, he even knew answers to questions that I did not. Thank God is what I thought I was born here. Upon receiving his citizenship, he asked me what he could do to repay me. He changed my life. They changed my life. And I asked him to keep playing and keep dancing so we could feel his rhythm. A bit later, when I was thinking about what the heck I was going to say to all of you today, it occurred to me that typically, well, I was going to say I express myself best in dance, but maybe not best. But nothing would please me more than be able to show you a piece of immigration that changed my life and touched my soul. Today, I am proud to present to you Jay Kalu. Their children, they were born here. They are US citizens. My drummers, my dancers, my friends. Jay Kalu. fallait à Balignon. That's actually Susu for today. Class is finished. Amazingly, J. Kalu means community. So does AILA. Community, a feeling of fellowship with others as a result of sharing common attributes, interests, and goals. At the very least, AILA is a professional community, a bar association, where people who perform the same work can obtain from it the tools they need to practice their profession. I truly believe that with just the InfoNet and AILA link, one has the tools to practice immigration and practice it well. But by also offering accessibility to mentors, practice management help, ethics guidance, media training, advocacy, and liaison assistance, AILA helps immigration attorneys become well-rounded and truly excellent in their field. But I believe AILA is much more than just a professional community. It is also a fellowship. I practiced law for 11 years before joining AILA, but I never experienced elsewhere the support, the camaraderie, and the professional generosity with my peers that I experienced and still experience here. So often have I heard people say that their AILA colleagues are their best friends. That is certainly true for me. This past year has presented some interesting governance challenges. While there are many lessons to be learned, I believe there's a silver lining in every cloud. And I think one of the things that we have learned is that AILA members care about each other and their association. Elie Wiesel once said, "The opposite of love is not hate, it's indifference. The opposite of art is not ugliness, it's indifference. The opposite of faith is not heresy, it's indifference. And the opposite of life is not death, it's indifference." So I ask you, please continue to engage with us. I assure you that myself, my ex-com, our national staff listen, and we care. For those of you that also know me, I will quote to you, "The needs of the many must outweigh the needs of the few." And we need to hear from you to know what those needs are. But I'm going to ask you that as we continue to engage this year, that you think of it as governance liaison. One of the most important things we ask of the government in liaison is that it view our petitions and our applications with a generous eye. That it not assume fraud or automatically make allegations and negative inferences from the things we present or what we do. That more likely than not is the general standard to apply. I think we should expect the same from each other in our governance. Let's lead the government by our own example. I'm looking forward to this year, to liaising with you and the government, to working together to make positive changes in immigration, to make things better for our clients, to making AILA the best it can be. Almost every Monday, Wednesday, and Saturday, I wake up with a special feeling. Those are dance days. Even though today is Thursday, I woke up with that same feeling today. It is a dance day. I hope that every day this year is a dance day. If that happens, I know we can accomplish our goals and make a difference. As in the words of the Hopi, to watch us dance is to hear our hearts speak. Thus, I ask you all, please, let's dance. Thank you.